Alpha OneTV aha na ba wotin sema chese ano ye din ye pa de din so beto other platforms no aha na ni nyine twego sesem ko bia so nsaka bia no like ya share ama onya so he den keep updated in so ready ye mfe ni nchirem na sabi da so gina a Supreme Court because case nda so ya de koso chese enya asem keto nsem bebre na chese koso na indeed Supreme Court ama NDC or hearing to some domasu nyina momo ana chese NDC for Akroma how mujawa chese high court judge or tena case in so no the you see the omo faso ye niema chinchin niema ema easy up to now no why ye niema bia chese ama Ghana for both ye papa na sabi as speaking I was seeing na no after watching this video I was seeing in shame near boy and sem kese pa ema eduji tamakulu wa yade pa wa yade or challenge a lot of judges a lawyer for kuku damages enya secretary na sabi eduji tamakulu etima koti some precedent be a Supreme Court ani nyina ne say Supreme Court in Jinaso, chess wa challenge wa challenge so Jinaso animanim ya and found quash all those a rule in a high court de ma easy no. Na a city na easy akọ forward akọ declare ama a NPP no. Yini nyina for because the omu nyina illegal. And ya senke to yen ko ninguti ni hwede.
I want to bring to your attention the decision of this court in the Republic versus High Court Bogatanga. S-Party Hawa Yakubu, 2001-2002 Supreme Court of Ghana Law Report at page 553, sorry. The Supreme Court had the occasion to quash the orders of the High Court in Bolga because the court said, Hawa Yakubu, who had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said she had the right to be heard, and that right was breached. And all the orders made by the High Court in Bolga were quashed. And the resulting effect that all the consequential orders, having been founded on those orders, must collapse with it. My Lord, the affidavit in opposition filed by the first filed by the Electoral Commission. The position made is that because proceed. Because the applicant parties at the time the application was heard, they deserve no rights, or there's no issue of breach of the rules of natural justice. So that is far-fetched. The application for judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or if he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. The EC knew. And that is exactly the decision of the Supreme Court in ex parte Hawa Yakubu. At this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission deposed to by Mr. Samuel Tete be expunged from the records of this court.
Why?
My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituent.
By stating that knowledge and information, didn't he?
Making respect, my Lord.
Yes.
One, he does not attach any official record or official document to the deposition or a police report of the returning officers detailing the so-called
Yes,
arrest
so
of fraud.
that weakens the weight.
Very well.
I don't think we.
No, my Lord, I just want to bring it to you
Okay.
that those depositions should not be.
May I respond to?
Oh no, we said that. The man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter.
Very
But
well.
you can't. Don't say we should expunge it.
My Lord,
Yeah.
the respondents say they had already done the collation. And so what is the point? You considering our application. My Lord, the morning of that Friday, with the greatest respect, I had appeared at General Jurisdiction 6 with my learned senior Justin Amenufo and Gary Nimako, where there was a pending injunction application against the Electoral Commission. That my Lord,
My Lord, so far, various applications have been made in this court in the course of submissions which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel. If he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the need. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel.
Please restrict yourself to the affidavit and let's go on.
Yeah.
yes, my Lord. So,
We don't
my
have the
Lord,
whole
no,
day.
my Lord. So our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us 2 days.
My Lord,
counsel.
this is not before the court.
Okay. So you haven't deposed. You haven't deposed.
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My Lord,
You were addressing us on what you said is the argument that
Yes.
the declaration has been done already. So address
my
us.
Lord, our quick response is that, in fact, in the Hawa Yakubu decision, orders were made, and those orders were even complied with. But when it was brought to the attention of the Supreme Court that there was a fundamental breach of the rules of natural justice, the decision and all the consequential orders founded on it were all set aside. My Lord, it is on this basis that we make this prayer. So, my Lord, it's on this basis that we invite this honorable court we urge on this honorable court to quash the orders of the High Court General Jurisdiction 13, my Lord, maybe just a quick point. In paragraph, my Lord, with respect, in paragraph 10 of the 2nd to 7th interested party affidavit in opposition, particularly paragraph 10, it is deposed to the fact that our agenda was heard.
Yeah, that's their case.
That our agenda was heard and dismissed.
Yes.
My Lord, with the greatest respect, the gender application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
The problem I'm complaining about, what you are alleging, my Lord, is not captured in affidavit.
Is that paragraph what?
To the paragraph where you said the joinder was heard. A joinder which was on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. I'm saying that we were not heard.
So it's different from saying that the
Very
joinder
well.
was
We were not heard. My Lord, nowhere in my Lord's ruling did he hear a say with respect that he heard our agenda and dismissed it. Nowhere. In fact, he himself said he will not allow the agenda to affect the quick hearing of the application. How can that same agenda be deemed to have been heard?
No, he said he gave you a hearing on the application.
Yes, my Lord, and that is what we are.
So it's not a joiner. He had before him an application for mandamus.
No,
and
no.
their case is that when you appeared, he heard you on the application for mandamus.
No, my Lord.
No, I'm trying to get you to understand their case because you are misrepresenting their case.
Very well. So, my Lord, the point we are making is that we were never heard on the application for mandamus.
Mr. Tomekulu.
Because first we were praying that we'll first be joined, then we'll be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My Lord, 1 minute.
Yes, I have it as A series.
Abusiafo a doji tamaklo na chese all on the floor of a Supreme Court chese wache nse muyi tinse oye learned chese unsure ni confidence level near high because or make sure say the right thing must be done because there is a saying say if it must be done well because as we speak right now no dear J men say you know once is Supreme Court only untimi ma ho 2020 Supreme Court apena business agree only ho untimi grama ho ka Kesi kefa ho pa adia wo ye no aye kan wontie no ba legal case na wayira yehu wo biem legal case bia na wayira ene wo na move forward can say yenye recollection wo na uji microphone ka say yenye recollection adenya nkrofo bi say ya force your constituency presiding officer wa kwa under training police service or NPP agent or ban say na NDC 40 midi how many konkonti ba bi gina also say by force declare NDC PC abrekra camera bian capture say obi de sekan gina okon ho edi to ahye wafu ho ka say when declare the sekan bo wana mebo tu ogun o fact ni saying imo remo dama go na che say ya bugina po ye boni petu mienu ekom suggest for police for ye she EC office pin sheeted be coalition ya titi bi mo che say ye butu ballot box na togu asewa skata baby o me coalition nyina no home pono EC nitimi ka say abugina po na wini EC say the course will be okay ade ye declare my MPP into a winning dey okay anu dey okay be bright and declare no the person you born to on constituency o elek pele ma kurugu ya declare no the person you born to on constituency o aden na mama Ghana no as if say MPP from Kwandia so akofa na appoint my opposition it doesn't mean say obey adwuma my MPP o akofa is not a president for a MPP MPP mum near Mao appointment they are fine to say a youth organizer for MPP general secretary for NPP so akofa do onye flag bearer onye leader my MPP o for Ghana so appoint wa oba be adwuma Ghana omba be adwuma ma NPP so ya ka busy sabri de o ya na oye ade akope Supreme Court ani kwase ke kodri sabri no o senka man for it mean ya time don person me bia no wa no akofa nse be nyina ba wa no akofa we nyina ba ka this time ka umma the right thing adwuma ka we nyina ba komo 9 seat 9 pe 9 pe hwemu how emu ha oni atete any emu secret meeting ahodo ekoso ti isi da ben na obiti Ghana for asem da ben enko ese wuti anaso wo ye adwuma ma one political party da ben ni purpose we da ben tina man for send a lot of petition ekoma John Dramani Mahama say e ben ya won sake onako because of actions ni nyema bia wo ye bebre ho a emfa kwem Emran with me chimney na favor. The same incident happened. Nasi yesu mrana wu chimney mani favor no yesu samra na ma wasi de bi emra for aden DNC. These are the things I cause into Akroma Supreme Court. And the edoji tamakuro quote a lot of precedents in a Supreme Court na sanka ruling or diabada. Precedent first Supreme Court na sanka ruling or diabada. Any agent so I can't share a Supreme Court say with their powers given to them and their mandate omunjina so because the same case nesi no omunjina so enfan kwashe a high court ni sema okanse is inquiry coalition enfan kwashe ni nyina sa seat na omujina so a high court ruling so jina so koko declare a 7 seat na man people no ni nyina no omunya ho adwuma na asemfa na asemko because justice Supreme Court of Justice attentrene mubu attentrene Ghanaians need justice. Those constituencies na NDC winning na ya jama MPP no those constituencies ni so mu hia justice amon pese akra na mako chusu omo MP amon pese constituency na nkasa vote omode ema one piece no eno ne engine so declare because omo na say chusu leader bit ma bomb because at the end no accountability ba sa piece na NDC ko chusu ni ma no sa piece na enkobu akonta nchire eje mensa onkobu akonta nchire IGP dampare obebu akonta nchire omanfo ni say akonta bi abrebi a obu na etwem no yempel as a leader yempel anodompre yempel as a leader ye probably obi foforo also want to say nti yensa fa no dom prena na nsi so omso mu hia justice nti na Mokoye sano moko tesano police station mokoye declare man no don pre no mo hihye ties ni ade do kwem no. They need justice. So we are expecting and counting on a Supreme Court say or no achese woye last hope magana. So mamu di ruling ba ntimi mfanko ba bia omo making sure say justice must prevail to protect our democracy as in same brain na yeti bit match under the comment section. So subscribe na share my news. Onye binti no so hu die ko bia 100%.